Now comes the stage of claim and counterclaim. The plaintiff has to serve a claim against the defendant in civil litigation. Proceedings are commonly commenced by using a Part 7 claim form, where there is a dispute of fact between the parties, with the issue being raised being defined in witness statements, which are served and relied on by the parties. This is the most common type of claim which you will come across in civil litigation. So, Part 7 claim form contains dispute of fact, and it is this kind of claim. But there could be other kind of claims which could be served in civil litigation. Those are Part 8 claims, where there is no dispute of fact between the parties, but the parties may want a term of the document to be constructed by the court, or where an infant settlement requires the approval of the court. These are the kind of claims which come in Part 8. The particulars of the claim, which may be served either at the same time as the claim form or within the 14 days of the service of the claim form. The particulars of the claim must be served either at the same time, but they must be served. The plaintiff must serve the particulars of the claim within the 14 days of the service of the claim form. Then comes the responding to the claim. Once a defendant has been served with particulars of the claim, then the defendant will be able to see what legal case is against him or her. So the claim form tells the defendant that what kind of wrong he has done or he might have done against the plaintiff. Now here is important thing. If the pre-action protocols have been followed, then there should already have been advanced exchange of information between the parties. That's why it is pre-action protocols are so important. Then there should already have been advanced exchange of information between the parties, and so the legal claim and the detail of it should not come as any surprise to the defendant. So the pre-action protocol makes a junction between the parties to tell each other that what kind of wrong that a defendant might have done against the plaintiff, and he doesn't get surprised when the case starts that what are the claims against him. The defendant will have a short time within which to respond. There are a number of options which are available to the defendant. Now, defendant has to respond to the claim. It may admit the claim but state that it needs extra time to pay. Like the defendant could say that he has done the wrong but he does not have the money, so he needs extra time. It may defend the claim and perhaps may also wish to bring a counterclaim against the claimant. And it can defend the fact that he has not done any kind of wrong which have been claimed against him, and put the plaintiff in the counterclaim that plaintiff has done in fact the wrong against the defendant. It may state that it is not to blame and may lay the blame at the third party, but it can also put the blame on the third party who is not at the party to proceeding. We will consider each of these options in some details in the civil litigation course in the future. We will also learn how to draft relevant documents. The defendant may also do nothing and hope that the problem goes away. It will then get what it is known as default judgment against it, and we will also consider the procedure to be followed to obtain a default judgment on the behalf of the claimant. and how to get the default judgment aside if it is served on the defendant.